Hi everybody, welcome back. So this is our final session online for the main lessons on our course. And of course we have two revision classes coming up in April. And in those two revision classes, the first class will be a revision of contract law and the second one will be a revision of tort law. Okay, don't forget though in between that you have an assignment to hand in. Deadline is the 23rd of March. Okay, hang on. Audio is static. Mine also. Okay, we'll see how the sound goes. If there are problems, then I'll whip in the technical wizards to sort out any problems. So we'll see how we go. If anybody else has problems with the sound, just drop me a line in the chat box. The chat box is open for any comments, questions, or queries. We shall start off with our review of private nuisance. Of course, private nuisance is the subject of question 2 in your assignment. Okay, same here. What's the same? Audio is static. What do you mean by static? Okay, well what we'll do is have a short break and I'll see if I can sort out the sound problem. Hey everybody, just checking the sound. Let me know how you hear me now. So testing 1, 2, 3, 4, and if everything's fine. Oh great, well done. Looks like it's much better. Thank you very much. Looks like we're ready to go again. Okay, so before the break we were talking about, well, I was talking about private nuisance, and then public nuisance we'll cover again today by way of revision. Question from Mr. Cheng Hong Man, who seems very keen on examination technique. Don't worry about that. Well, you already know. I mean, if you know your definitions and your principles, apply them to the facts of a case, and that's it. Remember, you use your definitions to identify issues, okay? And I've already given you the issues in question 1 of your assignment. Remember, the issue, you know, is there an offer? Well, I've been through it several times, all right? So remember, the main issue in question 1 of your assignment is there agreement between the parties, all right? And then with regard to question 2 on private nuisance, that's exactly what we're talking about now. Of course, your must-know definition is unreasonable interference with the plaintiff's, with the use and enjoyment of the plaintiff's land. Now, of course, what do you mean by unreasonable? Well, the courts have to strike a balance between the rights of the defendant to use his property for his own lawful enjoyment and the right of the plaintiff to be undisturbed, okay, unnecessarily. So the court has to strike this balance. So watch out for this in assignment question 2, and indeed in any question on nuisance, what is reasonable? Okay. The other important point to note, of course, he who asserts must prove. So if you're alleging private nuisance, you've got to prove it. So that might be difficult because you have to prove it's unreasonable. So if you have any question in the exam on, you know, unreasonable interference, then use your magic 2-letter word. If it's unreasonable, then of course that is nuisance, okay? But of course, if there is actually physical damage to the plaintiff's land, then that is unreasonable. So you don't need to go into any further analysis. So St. Helens Smelting and Tipping and ACL and Bulmer must-know cases. ACL and Bulmer is on page 97. So hope you've highlighted that in your favourite colour. All right. Mr. Cheng Hong again, would you provide a email? No, I don't give out my email address. So as a matter of policy, if you want to ask me a question, ask me during the class. And indeed, we've got the 2 revision classes coming up where I encourage people to ask me questions. As I say, it's a shame we can't meet face to face. Well, we haven't been able to do so for the last 11 sessions. But remember, when I always start off a session, I ask, are there any questions, queries, worries, anxieties, comments, suggestions? And I always finish a lesson with that, okay? So that's your opportunity to ask a question. And of course, if you are going to ask a question, it's always best to share it with the whole class, okay? All right, so you won't have any problems with the assignment, okay? The assignment, I think you have to advise 3 people on whether there is private nuisance. So first thing you do is, you know, write down the definition of private nuisance, and then, of course, whether it is unreasonable interference or not, that depends on the circumstances. As I've said, if there's actual material damage to the plaintiff's land, that's unreasonable. So ACL and Bulmer must-know case, and in ACL and Bulmer, there was actual physical damage to the property. I think what was it? It was, oh my goodness, yes, it was an uninsulated air conditioner room 24 hours a day. The air conditioning system made the room temperature so cold, created condensation and moisture on Bulmer ceilings. That caused physical damage. Actually, I'm in room 304 tonight. It is pretty cold, although I've had the air conditioning turned down, so it's not so cold. All right, so there was chipping and breaking of concrete and rusting of steel bars in the Bulmer case. That is unreasonable interference. Now, in your assignment, I'm not sure what the interference is, but if it's less tangible interference, then the court will look at those various factors. The timing and duration of the interference. Capital, Prosperous and Sheen must-know case, because remember, having a shower at night was not an unreasonable time, because Hong Kong people go to bed late. So think about that when you're having your shower tonight. Locality obviously is a factor. The locality principle laid down in Sturgis and Bridgman. Okay, it depends on which part of Hong Kong you're in. So what might be a nuisance in one of the fancier areas of Hong Kong, like the Peak, would not be would not be a nuisance perhaps in less salubrious areas. Realty harvest is a case, though, to bear in mind that you can still have private nuisance in an industrial area, because in the realty harvest case, the noise was so excessive, even in an industrial area. So it is a question of degree with reference to the facts of each case. Okay, so use your magic four-letter word if it is unreasonable. But remember, the burden of proof is on the plaintiff. The defendant's response to the plaintiff's behaviour, if you like, malice, or acting or in a way which amounts to antisocial activity, that would be unreasonable. So if you like, disproportionate response to noise and activity coming from your neighbour's property. Abnormal sensitivity, everybody, must know, must know. Your must know case is Robinson and Kilburt. The court will judge the situation and of that of an ordinary defendant, and in Robinson and Kilburt, it wasn't actually a defendant itself, it was their paper, which was, by the way, that's not damage to land, it was heat-sensitive paper which was damaged by heat from the neighbouring property. And the court said, well, the heat would not have damaged ordinary property. So the fact the plaintiff had super sensitive paper, okay, meant he was not able to show it was unreasonable interference. So abnormal sensitivity of paper in Robinson and Kilburt, abnormal sensitivity of the plaintiff themselves in the Sheen case. And in the Morris case, the court did find interference with an electrical tower, that was unreasonable interference because the court recognised that the use of electrical and electronic equipment was now common. So that was unreasonable interference. So each case does turn on its own facts. So watch out for that in your assignment. Who can sue is a very important issue. So in your assignment question 2, who can sue? You've got 3 people you're advising, potential plaintiffs, and all of them sue. Well, you apply the test in Malone and Lasky. Only a person with a legal interest in the land can sue. And who are the people you're advising? Ian, Jack, and Leo. So do all those have a legal interest in the property? I think the answer is going to be pretty clear when you apply the test. So Malone and Lasky is the test. Only a person with a legal interest in the land can sue. Well, what do you mean by a legal interest in the land? Well, you either actually own it or you are a tenant. Okay. Don't worry about Coruscant and Bush. That's history now. Just throw that in because slightly interesting facts. But the test in Malone and Lasky has been confirmed by the House of Lords in Hunter and Canary Wharf. Only those people with a legal interest in the land can sue. Lord Gough did draw up a list, if you like, of those people with a legal interest in the land. Freeholders. We don't have freehold property in Hong Kong, so that wouldn't apply in Hong Kong. Tenants, yes. So if you own a unit in a multi-storey building, you can sue. If you've rented it out to somebody else, then the person you've rented it out to can sue. And strictly speaking, that person would be a subtenant. Okay. Lord Gough did actually say that other category, licensees with exclusive possession. That would be extremely rare because if you do have exclusive possession, you normally do have a lease and have a right in land. But mere licensees cannot sue. So if you simply are on property like I am in room 304 today, I have permission to be in this room. Okay, but I can't sue in nuisance if somebody in the classroom next door starts making a big noise, okay? It actually happened during one of my classes once. And then we have the slightly interesting case of and Muir, in which there was a complaint about noisy sex going on, but I'm afraid the plaintiff couldn't sue because they didn't have a legal interest in the land. Similarly, in Artgo Properties, the plaintiff did not have any legal interest in the land. So that's obviously a key issue in your assignment question too. And of course, if the person you're advising doesn't have a legal interest in the land, they can't sue in private nuisance. A quick word about legal interest in land. Again, usually if you have a legal interest in land, you do have exclusive possession of the property. What is exclusive possession? It's you have control and dominion over the property so that nobody can be on the property without your permission, okay? And this, exclusive possession is an essential element in a lease, which is accommodation granted for a term at a rent with exclusive possession, okay? So exclusive possession, EP, does the occupier have a right to exclude the world at large? It's a question of fact. If you do have exclusive possession, you have a right in land, a proprietary right. The Latin expression is a right in rem, in the thing. If you only have a license, you don't have a legal interest in the land. That's only a right in personam. Okay, so I only have a license to be in this room at the moment. I can't sue in private nuisance. Land ownership in Hong Kong, we don't need to go through that again. Who can be sued? I went through this fairly quickly last time. This normally is not an issue. I think it's pretty clear in your assignment question 2 who the person is who can be sued, who the defendant is. Gets slightly, normally it's the creator of the nuisance, because that's going to be very clear in your assignment question. But what happens if the landlord has rented out the property? Well, good question, depends on the facts. There are two contrasting cases there on page 106. Tetley and Chitty, a defendant local authority, let out a parcel of land in a residential area to a tenant, knowing that the tenant was going to develop a go-kart business. And of course, that's obviously going to be very, very noisy. Okay, sometimes we have go-kart races in Victoria Park. I'm not sure where they go on again. So the court found it was reasonably foreseeable that the go-karts would create noise, and by leasing the land to the tenant for that purpose, the local authority was liable for the nuisance. Interesting. Why would you would think I would sue both of them, actually. By contrast, though, in Smith and Scott, which seems a more reasonable decision, the court found it was the tenant who was liable. The landlord was not liable for the nuisance created by the tenant, even though the tenant was a family known to the landlord as likely to cause a nuisance. The reason for that is that in the lease there was a specific clause saying that the tenant was not allowed to create nuisance or annoyance. So the landlord had expressly in the agreement put the onus back on the tenant. Okay, and then there are other cases on page 107. The landlord would be liable if he knows of any nuisance before letting out the property. Got a couple of cases there, Brew Brothers and Snacks and Lamb. Where in the second case, the landlord was liable for nuisance created by the predecessor. Again, more should know than must know. I think pretty obvious who's going to be the defendant, the person who can be sued, and that will be the creator of the nuisance. Watch out for defences. Okay, so this could be relevant to your assignment question 2. Remember, the main defence to private nuisance will be statutory authority or planning permission. Pretty well the same thing, anyway. It's authorised by the government. And statutory authority is the most important defence, and it is a total defence. Important to note, it is a total defence. Okay. So what's the difference between statutory authority and planning permission? Well, not too much for our purposes. Okay. And the question of whether statutory authority is a total defence depends on applying the question, is the act involved an unavoidable consequence of what the plaintiff has been authorised to do under the legislation? Okay, and that depends on the facts of each case. In the Lam Yuk Fung case on page 114, the court found that the defence of statutory authority did not succeed because on the facts, the rubbish was strewn all over the place, and people frequently came and left their rubbish at or near collection point, adversely affecting the environment. So on the facts, the court found that such a nuisance was not the unavoidable consequence of what the council had been authorised to do. Okay, so they had to have a better system of rubbish collection, that's it. And they could have avoided the nuisance through exercise of reasonable care. Of course, what do you mean by reasonable does depend on the facts of each case. Don't worry about the other defences, except perhaps, not for the assignment, but for perhaps a examination question. This has come up before in examination. Question part A of an exam, explain what is meant by the defence of act of God. Okay, well, this would be a natural occurrence which is not reasonably foreseeable. Now, of course, in the Star Ferry case, a ship was blown off its anchors by a typhoon, damaged the Star Ferry pier, so the Star Ferry company sued them. Okay, and yes, you could argue it was unreasonable interference, definitely, because there was property damage in the Star Ferry case. However, so looked like the Star Ferry company could prove all the elements of private nuisance, and of course they owned the land because they owned the pier, but the owners of the ship, the Argonaut, were able to rely on the total defence of act of God. They were able to prove that that particular typhoon was so bad that it was not reasonably foreseeable. Something overwhelming was found despite it being a natural occurrence. And if the court agrees, then it is a total defence. So watch out for act of God, not for your assignment, but it could come up in an examination question. And finally, and this applies to your assignment, question 2, what about the remedies for nuisance? Well, the most common remedy is an injunction because you want the activity to stop. So it's appropriate then for you to get a court order, an injunction, to stop the activity. And remember, an injunction is a remedy in equity, so the equitable maxims apply. Delay defeats equity. He who seeks equity must do equity, the so-called clean hands doctrine. And of course, usually the injunction is the most desirable remedy because you simply want the nuisance to go away. Okay. However, if there's actual property damage to the plaintiff's land, then the plaintiff can claim damages. Okay. So if there's physical damage to the property or indeed economic loss consequence upon the nuisance, that can be recoverable in the same way as in negligence. Okay. So I've got some facts there about how much damages can you get. Well, in Wong and Liu, it was $176,500. Have I got a page reference for Wong and Liu? 117. Wong and Liu. Where's Wong? Yeah, Wong and Liu, top of page 117. So I've given you the actual amount, the quantum of damages from Wong and Liu's $176,500 for loss of rental income. So there was property damage, and the property wasn't habitable for a certain time. So the landlord lost money, and he was able to claim, quite a decent amount of money, $176,500. Okay. Again, how much damages you will get depends on the facts of each particular case. All right. So remember, with regard to private nuisance, always be aware of the distinction between where the plaintiff's land has been actually damaged and where it's just intangible damage, okay? Because that does raise different issues. Okay. I don't know what Wong Patrick's got number 4 for. I don't know what that's all about. Okay, so that's pretty well it for private nuisance. Rylands and Fletcher, don't worry about Rylands and Fletcher. It's just a special type of private nuisance, which basically it's strict liability. If you can prove these elements in Rylance and Fletcher, then there's automatic liability. Okay, but Rylance and Fletcher, very, very narrow tort, and certainly not must know or even should know for our course. I've got on the screen comparison and contrast between private nuisance and negligence. Remember, you must have a legal right and land to sue in private nuisance. Although remember, and we'll look at this in a moment, you don't need it to be able to sue in public nuisance. So nuisance normally has a narrow application. By contrast, negligence focuses on the defendant's conduct, while nuisance focuses on the effect of the action on the plaintiff's land. Okay, which means, can you sue for damages for personal injury in negligence? Yes. Can you claim damages for personal injury in private nuisance? No, you cannot. Okay, so watch out for that. I'm not sure in the assignment whether any of those plaintiffs actually suffered physical damage, bodily, personal injury. Okay. Unreasonable interference, of course, you could argue that with regard to private nuisance, there is an element of fault creeping into nuisance. So there's an academic argument. There's a bit of an overlap between negligence and private nuisance. Anyway, not to worry too much for our purposes. Okay, so that's private nuisance. Now let's have a look at public nuisance, again, by way of review. So let me see if I can line up the PowerPoint smoothly. Are you public? Okay, there we are. Okay, so public nuisance. Not obviously in the assignment question, but it could come up in your examination. And public nuisance is both a crime and a tort. Okay. And public nuisance covers not just damage to the plaintiff's land, it covers a wide variety of activities, activities which endangers the lives, safety, health, property or comfort, and also morals of the plaintiffs. So it deals with material interference in general with the reasonable comfort and convenience of life of a class of subject. To sue in public nuisance, you've got to be a member of a class of persons, which is a pretty broad class. I mean, it could be road users, it could be, well, that's a common one. In the Castle case, it obviously was a road user who was a member of a class, and in Castle, in St. Augustine's links on page 110, he was driving his car on a highway, so he's a highway user, so that's the class he was in. He was hit and injured by a golf ball, hit off a golf tee. So he suffered personal injury. Now, can you claim damages for personal injury in public nuisance? Yes, you can. Okay, you can't do so in private nuisance. And the plaintiff did succeed in claiming damages for personal injury in public nuisance in the Castle case. On the facts, the court found that, the plaintiff had to prove those 3 points, which I think I've got here coming up. He had to prove that he was a member of the class of the public, and that was highway users, and he suffered special damage. Well, his special damage was his personal injury, and the injury was caused to him was of a foreseeable type. Well, certainly if you get hit by a golf ball, it's foreseeable you'll get injured. Okay, going backwards to the definitions of public nuisance, more a description than a definition. And the English cases have a sort of a description of public nuisance. Mr. Justice Ribeiro in the Leung Chung Hung case on page 110 adopted a fairly similar description of public nuisance. Okay, so there you are. You'll notice it affects not just the property of the plaintiff, it also affects his health. So this is why you can claim damages for personal injury in public nuisance. Okay. Also in the English description of public nuisance, it does say it affects the morals of the plaintiff. Okay, So this is why this list of activities on page 110 includes, among other things, keeping a vice establishment, which you could argue that affects the morals of the plaintiff. But it's interesting, that list of items which can cause public nuisance. Obstruction on a public highway, that's quite common. Okay, I've been involved indirectly in that myself. So watch out for when you're driving. If you're behind one of these dump trucks, they always dump things on the highway. Okay, throwing fireworks in the street, I'm not sure, well, that's possible, I suppose. Pigeon droppings. Okay, well, I've actually sat on benches in Hong Kong having my coffee, and suddenly I'll get a little bit of extra cream. Oh my goodness, the pigeons were in the tree over here. Keeping a vice establishment, already mentioned. Not properly maintaining a refuse depot. Okay, so resulting in offensive smells, that could be a ground for public nuisance. Pollution in general. Dropping objects from a building, that's unfortunately quite common in Hong Kong, isn't it? So if you are injured walking along a pedestrian path from something that has fallen from a building from above, then you can sue in public nuisance. The problem is, you've got to be able to find out who actually dropped that object. Well, you might have to call in the police. They might have to do a check, okay? So there can be a whole range of activities which can ground a claim in public nuisance. But watch out for the last point, very important with public nuisance. You do not require an interest in land to sue in public nuisance. You do require a legal interest in land to sue in private nuisance. Most important. Watch out for that in exam questions, because in past exam questions, in part A of the exam, you have been asked to compare and contrast private nuisance with public nuisance. Okay? Well, obviously, there's a big difference in that private nuisance covers unreasonable interference with the use and enjoyment of the plaintiff's land, whereas public nuisance covers a much wider range of activities. It's not just the effect on property, it also has the effect on life, health, morals, comfort of the public. Okay, so public nuisance is much wider in scope than private nuisance. And of course, the other big difference between private and public nuisance is that for private nuisance, you need to have an interest in the land to sue, not so with public nuisance. Okay? So we covered that last time. I think that case, the loan case, the Court of Final Appeal case on page 110, I think that's bordering on must know. It's almost the closest you'll get to a definition of public nuisance in Hong Kong. It is a Court of Final Appeal decision in which Mr. Justice Ribeiro, PJ, permanent judge, gave the leading judgment. And as I say, he adopted a description of public nuisance fairly similar to the Rail Track and Wandsworth case, which is on the screen, except for some reason Ribeiro left out the morals part of his definition. So it's a state of affairs which endangers the life, safety, health, property, morals, or comfort of the public, or obstructs the public in the exercise or enjoyment of a right common to all. Okay, so there you are. Another description, which is quite a useful one, of public nuisance is the AG and PYA Quarries case. And in that particular case, the court said that public nuisance is so widespread in its range, it should be taken on the responsibility of the community at large. So the PYA Quarries case is on page 109. Public nuisance is concerned with interference that materially affects the reasonable comfort and convenience of life of a class. Well, they're in England, so it does say of Her Majesty's subjects. Just say of a class of the public, okay? All right, so there you are. In order to establish a claim for public nuisance, prove a claim, you have to prove that the interference affects a class of persons and you're in that class, or at least injures a representative cross-section of the class. And then, of course, you've got to show special damage, okay? such as personal injury or property damage. Okay, so there you are. They're the elements of public nuisance, what the plaintiff must prove. Okay, and Castle is a good case. So if you get any question in the exam on public nuisance, Castle would be, you know, should know, bordering on must know. You could cite that. He successfully claimed damages in public nuisance. He didn't have a legal interest in the land. He didn't own the highway, but he was in a class of the public, a highway user. He suffered special damage, personal injury, and it was a foreseeable type of damage, being hit by a golf ball. By the way, I was hit by a cricket ball once, landed in Queen Elizabeth Hospital. So, golf ball, no problem. Cricket ball can do a bit of damage. Okay. All right, so with regard to cases, again, these are all just examples. So, I mean, each case does turn on its fact, but I think Mack and Chung involved a car crash in which there was a public nuisance claim because they had been blocking the highway. Ring and Cohen, again, structure overlooking a highway. So there are lots of highway cases when it comes to public nuisance. But in Hong Kong, watch out for things falling from property, from buildings, Leung and Chair. Chung and Sion is a case not in your course manual, but it involved objects falling from a building. Okay. And then Leung and Lee and the incorporated owners of Kwok Wing House. There's a case again on public nuisance. I haven't got a, where's my page reference for that one? Just one moment. Oh, it's in your course manual. Where is that Kwok Wing House case? Anyway. I suppose it doesn't matter with regard to that, but with regard to public nuisance, obviously in Hong Kong, quite a few cases involving items falling from buildings. And in the Leung and Lee case, it was a hawker injured by falling concrete. So it can be quite serious. Okie doke. So that's public nuisance. Don't forget the remedies for public nuisance, similar to private nuisance. Usually an injunction, but of course, probably more often than not, your remedies for public nuisance can include damages because you can actually claim damages for personal injury. And as we've noticed from these instances of public nuisance cases, it's, you know, obstructing a public highway, things falling from buildings can actually cause quite serious personal injury. And of course, certainly if there is property damage, you can claim damages. Okay, so, and you can also claim damages for pure economic loss as a result of that personal injury or property damage. Okay, so an injunction is also possible depending on it. If it's of a continuing nature, you know, like something overhanging a highway which might potentially fall down, you can get an injunction to remove that barrier that might be on a highway. Okay, so that's the remedies for public nuisance. And then comparing and contrasting private and public nuisance. I've got a case there of Lam Yuk Fung and the Attorney General, which is in your course manual, top of page 114. Again, smut from an oil depot caused, sorry, I'm not sure if that's actually the same case, but I think it's a very similar name, anyway. But if you parked your car in a street and that's damaged by some emission from a factory, then your claim would be in public nuisance, particularly if your car has been damaged. Okay, you would be in a class of persons, namely persons who park their cars on a highway, and you would have suffered special damage if your car was injured, so you could sue in public nuisance. You would not have to show, you would not have to have a legal interest in the land. Okay, so there you are. Smut from an oil depot, damage to property itself. That's, you can sue in private nuisance. If your home was coated in the oil, that would pretty well be property damage. But damage to your car parked in a street, your claim would be in public nuisance. Okay, so that's just sort of comparing and contrasting the two. Okay, everybody, so that's our review of nuisance. And so let's have a look, an introductory look at least before we have our break, at Occupiers Liability. If I can find it. Where are you? Are you? Yes, here it is. Okay, so remember our two major torts on our course are negligence and nuisance, all right? A tort which is closely related to negligence is occupiers liability. So I don't know what to. So one reason for going through occupiers liability is to compare and contrast the two. So in a way, it's sort of a revision of our work on negligence. Remember, however, occupiers liability is much narrower in scope than negligence. Occupiers liability is only concerned with the occupancy duty. So it's only if you control premises, okay? And so in other words, you are what we call an occupier. If you do, then you owe a special duty very similar to a duty of care to people who visit your property. And the people who visit your property are actually called either visitors, because they are there with permission. If the people are on your property without permission, they are called trespassers, okay? So occupiers liability only occurs when in that particular situation. It's only concerned with the occupancy duty, injuries arising from the defective state of premises, not with any particular activity. So, you know, because you won't go onto property and you fall over and injure yourself because there's some, you know, a staircase has collapsed or something, then that's more in the area of occupiers liability. In practice, quite often, a set of facts can be the basis for both negligence and occupiers liability. You can sue in both. You only have to succeed in one of those actions to get your remedies, which would normally be damages, okay? So an example of occupiers liability is, say, a staircase handrail falling. That would be occupiers liability. However, scalding by pouring tea, that would be in the area of negligence, okay? So remember the case we dealt with when we're dealing with breach of the duty of care involving scalding tea, Glasgow Corporation and Muir, okay? So this occurred on property, but it was resulting, if you like, from an activity, wheeling the tea urn through a crowded room. And remember, some of the boys got injured. Did the occupier owe a duty of care? Yes. Was there breach of the duty of care in Glasgow and Muir? On the facts, the court said no, because they looked at the standard of a reasonable defendant in the circumstances, and on the facts, the defendant had done everything reasonable to make sure that the people on the property were safe. So the facts of Glasgow and Muir could also be ground for occupiers liability, although the main cause of action would be in negligence. So interesting that the Hong Kong courts are expanding the law on occupiers liability to work site activity. So they do overlap, these two. You know, it used to be occupiers liability only deals with static things on property. If there's any sort of activity going on, you know, where you fall over or something, then all right, that's more negligent. But they do overlap, and as I say, in a particular set of circumstances, you may well plead both common law negligence and occupiers liability. Okay, and in Hong Kong, the courts are very keen to protect workers, particularly on construction sites. And so the courts have been expanding the operation of occupiers liability to work sites. Okay, so with regard to occupiers' liability, who is an occupier? Well, the occupiers' liability, from the previous PowerPoint, is governed by legislation called the Occupiers Liability Ordinance. Now, everybody, I challenge you to go and read the OLO because it's not a very long ordinance. The wording is pretty clear. It closely follows the legislation in England. Okay, so first of all, then, who is an occupier? Well, the legislation doesn't seem to be doing a very good job, does it? Because it doesn't even define who an occupier is. So in order to decide who an occupier is, you have to rely on case law or the common law. And that's what Section 2, Sub 2 of the OLO says. So what are the cases in this area to decide who is an occupier? Well, the leading case is a case called Wheat and Laken, which always sort of reminds me of a breakfast dish, bread and bacon. No, Wheat and Laken. And the test is, did the person have sufficient degree of control over the premises? Basically amounts to exclusive possession, okay? So if you have exclusive possession, you have control and dominion over the premises. So in Wheat and Laken, the test laid down for who is an occupier is very similar to that for whether the person has exclusive possession of the property. Did he have a sufficient degree of control over the premises? So that's who that is, okay? CAP 314, Occupiers Liability Ordinance, okay? As I say, it's not must know for our course, no. So why am I going through it? Well, because it should know, because it's very closely related to negligence. And as I say, indirectly, we are revising our work on negligence, okay? So who is a visitor? So we're talking here about the plaintiff. Is the plaintiff a visitor? Well, do you have permission to be on the property? If you have express permission, certainly then you are a visitor. So if you are on property because of a contractual license, such as I have with Space, I've signed my contract with Space, which enables me to be in room 304 of the Admiralty Centre tonight. So I am a visitor. I have express permission because it stems from my contractual license. Okay. However, there are situations in which the person on the property may not have express permission, but they may have implied permission. And there's a case called Phipps and Pear, which says, depends on the facts, has the occupier knowingly tolerated regular intrusions? So if you know that people are regularly going across your property and you haven't done anything about it, then the court will assume that that particular person has implied permission to be on your property. And if so, they are a visitor and the legislation applies. And if so, then the occupier does owe a duty to that person. It's actually called the common duty of care. It seems a bit strange, but under the OLO, the duty is called that, a common duty of care. So you can see a very close overlap with common law negligence. Okay. Also, another issue here with regard to whether a person is on property legally or not with permission. Has the occupier done anything to discourage or warn visitors? You know, trespassers will be prosecuted, that type of thing. And in Chen Kwai Nor, it was a restaurant case in which somebody was getting hungry. And so they got up and walked towards the kitchen. But when they got near the kitchen, it was very slippery from all the cooking oil, etc. They fell over and injured their back. So they sued the restaurant, and they sued them both negligence and occupiers liability. But the restaurant said, hang on, there's a sign there saying, you know, customers are not allowed beyond this point. Do so at your own risk. The court said that that particular notice, however, was in the wrong place and the wording was too small. And so the court found, even though there was a sign to discourage people going near the kitchen area, the sign was not sufficient to discourage or warn visitors. So the action for occupiers liability in Chan Kwai Noa did succeed. Okay. All right. So if you're hungry though, don't do silly things. Remember where we're talking about defences to negligence, remember Valenti and the Shatwell case? Well, remember the person there was hungry, so he shortcut the safety procedures and then sued. So remember the court in the Shatwell case found there was a total defence of Valenti. So don't do silly things if you are hungry. Okay, well, you may well be a little bit hungry now, everybody, so I think it's probably a good time to have our break. So we'll have a break, and then after the break, we'll finish off occupiers liability. And then later on tonight, I will have a word to you about examination technique, because Mr. Cheng Hong Man seems hell-bent on some examination technique points. I've already flashed up the points about the assignment. Remember the assignment due on the 23rd of March. I will say a few words about that again after the break, but I've already said quite a bit about the assignment. But also I will go through some points about examination technique generally, because this will help you with your revision of the whole course, both the contract side and the tort side. Okay, so we'll do that, but not just yet. We'll do that after we finish our work on occupiers liability. So let's have a break now. After the break, we'll carry on with occupiers liability. Okay, welcome back everybody. Hope you had a good drink. Yeah, not a shower. Have your shower later and then you think about capital, prosperous and sheen. Okay, so talking about occupiers liability, remember sort of indirectly revising our work on negligence. Your course manual does actually briefly mentions occupiers liability on page 12. It says occupiers liability refers to liabilities imposed on an occupier of premises to ensure that the premises are reasonably safe and free from dangers or hazards to visitors and other persons who may come to the occupier's premises. Okay. And remember, before the break, I was talking about a certain set of facts may give rise to the common law tort of negligence, but also give rise to a claim in occupier's liability, and could also give rise to another tort, which I mentioned briefly before. Of course, this is all should know, not must know, called breach of statutory duty. So particularly if you're a worker on a building site in Hong Kong and you're injured, then you could claim all three. And of course, you only need to succeed in one of those actions to get your compensation. All right. So that's that. And of course, with regard to the employer-employee relationship, of course, the law is very keen to protect workers' rights. The law used 100 years ago was not so good at protecting workers' rights. And even today, you could argue that the law doesn't sufficiently protect employees when they're working on premises. But Hong Kong has done pretty well in that we have an employees' compensation ordinance. We also have courts who are very sympathetic to claims which arise where workers are injured at work. And indeed, the duty of care owed by an employer is higher than normal. The duty of care imposed on an employer is very similar to this occupier's liability duty to keep the property reasonably safe and free from danger. So you don't want to be going into a workplace in which the employee is likely to get injured. Okay, I mean, I'm in the office at the moment facing two computer screens. Obviously, I'm reasonably safe. Okay, but of course there are other occupations which are not so safe. So, the tort of occupiers liability, very close to the tort of negligence, and the tort of occupiers liability originates from the common law, but is mainly governed by legislation. So it's good to see some of you looking up the Occupiers Liability Ordinance, Cap 314, you're correct. And Section 2.1 of the Ordinance says that the rules enacted by Sections 3 and 4 shall have effect in place of the rules of the common law. However, as I say, good, but we've noted already that the Occupiers Liability Ordinance doesn't define who an occupier is. So you would think they should have, thought a little bit about that and put some definition of an occupier in the legislation. Why not just take the ratio of the case of Wheaton Laken? An occupier is somebody who has sufficient degree of control over the premises. Okay. All right, or they could have come up with wording similar to that. So the ordinance is there to regulate the duty which an occupier of premises owes to his visitors. What about the duty owed to trespassers? Does an occupier owe any duty to a trespasser? Good question. Well, it's not the same duty as that to a visitor. Okay, and we'll look at what duty an occupier has to trespassers. You might think, well, the trespasser's not supposed to be there, so why should the occupier owe him any duty? Good question. Okay. But certainly an occupier of premises owes duty to his visitors in respect of dangers due to the state of the premises or things done or omitted to be done on them. So drawing this distinction between negligence applying to activities and occupier's liability applying to simply the static state of premises, the boundaries between the two are not all that clear anymore. So you can plead both. All right, so who is a visitor, though? That, again, depends on the common law. And, of course, a visitor is somebody who's on the premises with permission. And the permission can either be express permission, usually contractual permission, or it could be implied. For example, if you're visiting a shop, you don't sign any contract to enter. It's sort of implied permission that you can enter a shop to buy something, all right? And then, of course, with regard to trying to exempt liability, the occupier might have some sign which could amount to the person not being a visitor, in which case there will be a trespasser. But if you're going to have a sign which is going to discourage or warn visitors not to go in a particular area, the sign has to be effective. It has to be in the right place, and the wording has to be appropriate. And in the Chan Kwai Nor case, the sign was not effective on the facts. So there was occupiers liability in that particular case. But as I say, it was the hungry customer who was very impatient and lost patience, so they got up from their table and walked towards the kitchen area. They slipped over and suffered personal injury. I think it was injury to the back. They slipped over. Okay, and so they sued the restaurant successfully in occupiers liability. So the restaurant was not able to rely on the sign to as some sort of defense to a claim for occupiers liability. Okay, now what do you mean by premises? Good question. Again, not defined in the OLO. Funny word, premises, isn't it? It really means sort of buildings, but it includes all varieties of buildings, land, and structures on the land. But interesting, section 2, sub 3 does say the same liability about premises applies to fixed or movable structures, including any vessel, vehicle, or aircraft. So I remember when I was a trainee solicitor, I was asked to advise on whether somebody who was injured on a boat in Hong Kong could claim an occupiers liability. Well, there's your answer in section 2, sub 3. It includes any vessel, vehicle, or aircraft. Okay. And then I've got, I don't know, I got reference to page 56 there. Ignore that reference to page 56. Scaffolding is included in the definition of premises. That's an interesting one. Okay. So premises is pretty broadly defined. It covers all varieties of buildings, land and structures on the land, plus all those other items mentioned in section 2, sub 3, including any vessel, vehicle, or aircraft. So it's interesting, if you're in a vehicle, normally, you know, if somebody's injured in a vehicle, you claim in normal common law negligence, but you could also claim theoretically in occupiers liability. I guess that would refer to bigger vehicles like a bus, for example. All right, so what is the occupier's duty? And remember the elements of negligence. The defendant must owe a duty of care to the plaintiff. And of course, there must be breach causing damage, which is not too remote. So what is the occupier's duty? Well, this is actually stated in section 3, sub 2 of the OLO, and it's called the common duty of care. I don't know why they call it the common duty of care, but that's what it does say. And if you get hold of that ordinance, you'll read it says to take such care as in all the circumstances of the case is reasonable. Now, very imprecise language. In all the circumstances of the case is reasonable. Where's that word reasonable again? To see that the visitor will be, again, reasonably safe in using the premises for the purposes for which he is invited or permitted by the occupier to be there. The problem with all that, of course, everybody, that wording is very vague. And if you are alleging occupiers liability, claiming occupiers liability, you've got to prove all the elements of occupiers liability. Well, that could be a little bit difficult here, right? Circumstances of the case is reasonable to see that the visitor will be reasonably safe. So, I mean, how many times have we come across that word reasonable? Okay. All right, so that's the occupier's duty. What is the standard of care? Here, of course, we're talking about breach, but with regard to children, remember with regard to common law negligence, the court will look at, with regard to children, will look at the reasonable defendant in the circumstances. And if the child is the court will look at, well, if it's a child involved, it's an ordinary child of that particular age. And it's interesting, Section 3.3a does say in the Occupiers Liability Ordinance that children are less careful than adults. So the standard of care imposed on occupiers is a bit more demanding when it comes to children. Of course, children go onto any sort of property, they run around, they jump up and down and all the rest. Okay, I mean, you only have to see that when you're on the MTR going home sometimes, all right? When they're, well, not so much going home if it's late at night, but, you know, kids run around all over the place. And then there are lots of cases there which we don't need to worry about, but they do involve children, and the fact that children, if you like, are less careful than adults. So that has to be taken into account. And so, if you like, that imposes a higher standard on the property owner to protect children. You could also argue, hang on, aren't children supposed to be controlled by parents? And could you argue the parents are contributory negligence? And there is a case there called Taylor in which the court did find that there was contributory negligence. Okay. Also, with regard to the standard of care of a visitor exercising a calling, well, what sort of standard is this? Well, this is where somebody, a professional person, comes onto your property to fix something. So in English case of Rolls and Natham, a chimney sweep coming on. There was special risk associated with sweeping chimneys, and the victim was supposed to take care of himself. So there was no liability by the occupier to the chimney sweep, because if you like, he's in a specialised role and he has to sort of look out for himself. But there could be joint responsibility of the occupier and the victim, depending on the circumstances. I remember when I got somebody come in, change my air conditioner once, he climbed out the window, was on scaffolding and all the rest. Oh my goodness. Okay, well, if he fell down and got injured, I would not owe him. Okay, I would not have to, I wouldn't be liable because he's a visitor exercising a calling. All right, and then what about the role of notices? I mean, what are notices there for? Well, remember, we've already looked at the possible function of a notice to withdraw permission from a person on the property, so that instead of them being a visitor, they will be a trespasser. Okay, so it depends on what the notice says, but if the wording is sufficient, it can be amount to withdrawing permission for that person to be on the property. And if so, the visitor V becomes a trespasser T, and no common duty of care is owed. Which reminds us again, is there any duty owed to a trespasser? The answer is yes. We'll look at this shortly. So there is a duty owed to a trespasser, but it imposes a much lesser burden on the occupier than the common duty of care. So a notice could be there simply to withdraw permission to make the person who's on the property a trespasser rather than a visitor. And if they're a trespasser, then the occupier doesn't owe them a common duty of care. Also, the notice could be a warning, as in the Chang Kwai Nor case. Remember, the person who was impatient waiting for their meals got up and walked towards the kitchen area and slipped on the greasy floor and suffered personal injury. Well, there was a notice there of some sort of warning, but the court said it wasn't sufficient to discharge the common duty of care. It does depend on the facts if the notice is sort of a warning. Also, remember from our contract law, the notice may amount to an exclusion clause. And remember, such as, people who enter these premises do so at your own risk. And remember what an exemption clause is. Everybody, you know, don't you? An exemption clause is a clause in a contract which seeks to exclude or restrict liability. And liability could be either responsibility or risk for either negligence, breach of contract, or misrepresentation. Well, here we're talking, of course, about trying to exclude liability for negligence. So could you argue that a notice could amount to an exclusion clause? Okay, and if it is an exemption clause, remember it will not be effective if it's aiming to exclude liability for negligence causing personal injury or death, Section 7 sub 1. Remember Section 7 sub 1 of the Control of Exemption Clauses Ordinance must know, and remember Section 7 sub 2, can you exclude or restrict liability for negligence causing other damage? Well, you can, but only if it is reasonable. Okay, so there you are. That's another function that a notice might be aiming to do. Can you exclude liability to a trespasser? The answer actually is yes. You can exclude liability to a trespasser. This is a technical argument, but if you look closely at the wording of Section 2(1)(c) of the CECO, it does say that it is possible to exclude liability to a trespasser. That's a technical argument, but it is strictly possible just looking at the wording of the Section 7 and also Section 2(1)(c) of the CECO. All right, so there you are. Interesting. You can see, again, everybody, this is a situation in which tort law overlaps with contract law. Okay, hang on, I've got a question here from Law Suquan. Would occupier be sued for negligence if attendees do not wear masks and transmit a COVID over the current epidemic control ordinance? Okay, I'm not sure about the epidemic control ordinance section. Well, it depends. You could have a sign at the entrance to the building saying people who enter here must wear masks. You could also say keep your social distancing, have your temperature checked, and make sure your hands are clean. Yes, you can attach conditions to the entry to a particular building, and providing you've got a notice there which is in the right place, in the right language, then that could be sufficient to withdraw permission from people entering into the property. So if they do not abide by the conditions of entry, then instead of being visitors, they would be trespassers. So the occupier wouldn't owe the common duty of care. He would still owe a duty, which we're about to look at. What duty, if any, is owed by an occupier to a trespasser? Okay, so good question. That shows your thinking. And also remember, with regard to that third point on the screen, might a notice be an exemption or exclusion clause? Don't forget your definitions, okay? Must know definitions. So Mr. Cheng Hong Man was asking, any particular hints for the exam or the assignment? Well, those of you who read my comment, I think I actually made it. Where is it? I said, yes, make sure you know your definitions and principles, okay? And be able to apply them to the facts of an examination question. I'm going to talk a bit more about examination technique later on tonight, okay? But at the heart of any preparation for an examination is everybody, you are law students. What is your main task as a law student? Your main skill, if you like, is to identify issues. And what is an issue? An issue is a question for the court to decide. So remember, there are arguments for and arguments against. And so you should be able to appreciate, you should be able to actually be a lawyer for both the plaintiff and the defendant and see what the relative arguments are. And of course, it's up to the judge to decide which argument is the stronger one. Remember, you can't go to court unless there is an issue. And if you go to court and there is no issue, the court will say, what are you doing here? You're wasting our time. Go away. There's got to be an issue. Okay, so there you are. So make sure you know your definitions and your principles. And then you know what an exemption clause is, everybody. It's a clause in a contract which seeks to exclude or restrict liability or risk or responsibility for either negligence, which is what we're talking about here, breach of contract, or misrepresentation. And remember, where does an exemption clause fit in? It's raised as a defense to a claim for either negligence, breach of contract, or misrepresentation. Which reminds me again, everybody, you know the definition of misrepresentation, don't you? Well, check yourself. What is a misrepresentation? A false statement of fact made by a party to a contract which induces the representee to enter into a contract with the representor, full stop. But must know that definition. And remember also the burden of proof is on the representee, and the representee also has to do what else, everybody? You know, don't you? The representee also has to state what type of misrep they are claiming. Remember, there are three types of misrepresentation: fraudulent, negligent, and innocent. So which type of misrep would you advise your client to claim? You know the answer, everybody, don't you? If you don't, you better write this down. You advise them to claim negligent misrepresentation. And you know the answer. Why? Why? Because the burden of proof is reversed and put on the representor, section 3.1 of the misrep ordinance, because of the two words, he proves. It is a heavy burden of proof, as shown by the Court of Appeal decision in Howard, Marine and Ogden. And most controversially, the level of damages for negligent misrep is the same as for fraudulent misrep, the so-called fiction of fraud, because of the two words so liable. And remember, that was decided by the Hong Kong courts in the Pepsi Cola case, and the English courts actually followed Hong Kong, Roy Scott and Rogerson. Okay, so remember the definition's absolutely critical, okay? And of course, I'm straying a little bit back in contract law, but remember, misrepresentation is also an area in which contract law and tort law overlap, okay? And once you know the definition of misrep, appreciate that a negligent misstatement can also be negligence, common law negligence, Headley, Byrne, and Heller. Okay, so here we have on the screen a notice which could be put up by an occupier, and it's trying to exclude liability for negligence. That, of course, might be in the nature of an exemption clause. Will it be effective? Well, section 7 sub 1 said no, because you cannot exclude liability for negligence causing death or personal injury. And you can exclude liability for other damage, but only if it is reasonable. That's section 7 sub 2. Okay, so moving on now, quickly about independent contractors. Does an occupier owe any liability to independent contractors? Well, normally the occupier is not liable if there are reasonable steps taken in choosing and supervising the independent contractor. So if somebody comes to your flat to repair your air conditioner or whatever, or any electrical work, all right, provided you've chosen, somebody who's registered, then you'd not be liable at all if they're injured in performing their duties on your premises, okay? However, there's a case on the screen which we don't need to worry too much about. Sometimes it is possible for the occupier to be liable if they don't properly supervise an independent contractor. Okay, so moving on to defences. And of course, indirectly, this is a revision of our work on negligence. Remember, there could be the defence of volenti. There could be somebody who satisfies all the elements of volenti, so that could be a complete defence. Remember, volenti is a total defence, and that can be raised as a defence to occupiers' liability. Remember that case involving the lady who, I think it was the Geary case, riding down the staircase, and she got injured, okay? And so in fact, she got very severely injured. She broke both arms and both legs. She's a tetraplegic. And so she sued the restaurant or the bar, and she sued in both negligence and occupiers' liability. But the bar successfully claimed volenti, okay, because if you're doing something on the premises which is inherently dangerous, and it's something which the occupier hasn't authorised you to do, like riding down a banister instead of walking down the steps, then that could amount to consent. So in the Geary case, the court found that the total defence of Volanti succeeded. So even though the lady was very severely injured, she couldn't claim any damages in either negligence or occupiers liability. So Geary is a good case in which the facts can give rise to both negligence and occupiers liability. Okay? And remember, with the defences we looked at before, Volanti, extirpi causa, and contributory negligence all apply to both negligence and occupiers liability. I haven't got illegality. I can't remember. Well, I suppose if you're on property robbing it, then that probably would be a total defence of extirpi causa. Okay, but that would be pretty unusual. But contributory negligence, everybody, is a very common defence to a claim for occupiers liability. And remember, everybody, the law on contributory negligence is primarily in legislation, and you know the section 21 of LACO. Okay, and so remember, the person has to be partially at fault. The person who's claiming, the plaintiff, has to be partially at fault, and so then it's up to the court to decide on the facts of the case how much, if any, the level of damages will be reduced by. So it does depend on the facts of each case. So I remind everybody of the importance of section 21 of LACO. Okay, so I'm always, well, not always, but often disappointed when students are dealing with the defences to either negligence or occupiers liability. Obviously, it's negligence in your exam. The number of students who forget to mention section 21 of LACO. Section 21 of LACO is up the top. It's the number one source of law dealing with contributory negligence. And of course, there are lots of cases on contributory negligence, yes, and it depends on the circumstances. But remember, all those cases that we listed before when we dealt with contributory negligence are just, on the facts of a particular case. And remember, the Hong Kong courts of saying, all of those cases are just, on the facts of that particular case. And so you can't really come up with hard and fast numbers for the quantum of reduction in any claim for damages for contributory negligence, except perhaps Ho Wing Chung with regard to seatbelts. So yes, Ho Wing Chung is your, I would say, second must-know source of law on contributory negligence. So with regard to seatbelts, okay. So with regard to seatbelts, remember, if you are going to claim contributory negligence, you've got to prove that the plaintiff is at fault. That's the first thing you have to do. And of course, you could argue if he's not wearing a seatbelt, he's at fault. But you also have to prove that there's breach, if you like. Would a reasonable person wear a seatbelt? Yes, they would. Okay, and so normally if you don't, then that would be contributory negligence. But it does turn on the facts of a case. Chen Wing King, remember the pregnant lady? There was no contributory negligence there. And also with regard to contributory negligence, remember the defendant has to prove causation. So Wong So Ching. Okay, so they are your must-know cases on contributory negligence. So it's first of all, section 21 LACO. That's up the top of your list of sources of law for contributory negligence. Then Ho Wing Chung, second. So Ho Wing Chung, first of all, remember the defendant's got to prove that the plaintiff hasn't come up to the required standard of care. So Ho Wing Chung is your case on seatbelts. A reasonable passenger would wear a seatbelt. And also Ho Wing Chung is also on the quantum of reduction between 15 and 25% for seatbelt cases. And then Wong So Ching also is a case which highlights the fact that the defendant also has to prove causation in order for contributory negligence to succeed. Okay, so contributory negligence, everybody absolutely must know. Remember, top of the list for your sources of law for contributory negligence, always section 21 of LACO, and then of course add in those cases that we've mentioned before. All right, everybody, now just to finish off occupiers liability, is there any duty owed to a trespasser by an occupier. Well, you might think no, because he's not supposed to be on the property. If you're committing a criminal act, you should not be on the property. So the Occupiers Liability Ordinance does not extend to trespassers. So the legislation only applies to visitors, okay? So occupiers and a visitor. The Occupiers Liability does not apply to trespassers on property. So is there any duty owed to trespassers at all? The answer is yes. There are English case, British Railways Board and Harrington, followed in Hong Kong in the Wong Wing Ho case, in that the occupier does still owe a duty to a trespasser. And the duty is commonly called, commonly described as the occupier acting with common humanity. Common humanity. Interesting. What does that mean? You can't sort of put booby traps on your property so that if trespassers come in, he gets blown to smithereens. So you've got to act with common humanity, and it depends on the occupier's knowledge, ability, and resources. So the question the courts will ask is, how easy is it for the occupier to keep the trespasser free from injury? So there you are. Interesting. You've got to, the occupier has to act with common humanity. You can't have items on your property which, can cause very serious injury, even to a trespasser. Okay, so there you are. But of course, if you're going to be on property, I suggest you be a visitor, because then you are owed the common duty of care. Okay, everybody. So that's finishing off occupiers' liability. So what I want to do now is have a short break again. After the break, I want to discuss with you examination techniques, because Mr. Cheng Hong Man has been raising this. And we'll go through this again when we do the revision course, but this might help you with your revision for both contract law and tort law. So if you, and particularly those of you who haven't answered many law questions before, there's a definite technique to use when you're answering law questions. So what I'm going to do is take you through examination technique, and I'll also try to cross-reference it to the assignment, so that after tonight, everybody, you should be very confident about doing your assignment. You should already be quite confident about it. You all know how to do question 1. I will go through that again briefly again after the break. You all know how to do question 2 as well, because we covered that earlier tonight. But I will talk about that briefly, the assignment again, and then talk to you generally about examination technique. Okay, so we'll have our short break now, another 10-minute break, and after that break, then I'll come back and talk to you about examination technique. In the meantime, if you've got any questions generally about the course, any legal issue that's bothering you, or anything about examination technique, the chat box is open, so you can drop me a line, and I'll take that up if I get any questions. Okay, so let's have our second short break now. It's probably the appropriate time to do it. And after the break, we'll come back and talk about examination technique. Okay, everybody, so in the chat box I've typed into the final stretch. So what I want to do now is talk to you in general about examination technique, because when it comes to answering law questions, there is a certain technique which you need to be able to apply. And it reminds me when I did my very first question on contract law, I was very brief. I finished in about 6 lines, and of course it was on whether there was a contract between A and B, right? And of course my previous degree that I'd done was science, and so in science, you know, A equals 3 or X. But I failed to appreciate that when it comes to law, remember, the important thing is to identify an issue. And what is an issue? As I've mentioned quite a few times before, it's a question for the court to decide. And how do you identify issues? From your definitions. So everybody, quick check on the definitions, must know definitions. First of all, for contract law, remember you must know the definition of offer, acceptance, consideration, exemption clause, misrepresentation, and frustration. They are your 6 must-know definitions. I trust you've written them all down somewhere, okay, and also burn them into your brain so you can reproduce them without hesitation, deviation, or repetition. So if I am going to run into you, which I hope I do in the revision courses, which are in April, that I should be able to point to anybody in the class and ask them to tell me any of those definitions. Oh, by the way, what is frustration? Remember, frustration occurs when, without fault of either party, a contractual obligation has become either impossible, illegal, or radically different from that which was undertaken by the contract. You know the case, House of Lords, Davis and Fareham. Okay? And remember, the whole point of these definitions is not to test your memory, it's to be able to use them to help you identify issues. Okay? And this is why, for example, in your assignment question 1, and by the way, when you start off an answer to a question which says advise somebody, okay, always use the wording of the question. Okay, I've lost count of the number of times when I've been marking exam papers and I get to about page 2 or even 3, and I put a big horizontal line and then I write 2 words, start here. In other words, what is very important for students answering law questions is make sure you are answering the question from the word go. So I'm not sure exactly what the wording in is question 1 of your assignment or question 2, but I think you're asked to advise somebody. So always turn that wording around. Somebody would like to know what? Well, hopefully the question will give you a pretty good indication of what they would like to know. So in question 1 of your assignment, for example, whoever it is would like to know if there's a contract between him and the other person, full stop. You are immediately being relevant. That's a key word in answering law questions. Stay relevant. Relevant to what? Relevant to the question and then to the particular issues that arise in the question. So in question 1 of the assignment, your next sentence would be, the court will look for essential elements in the formation of a contract, colon, agreement, consideration, intention, etc., full stop. Okay, and then the only element in issue in question 1 of your assignment will be the element of agreement. Okay, and so you write down the Gibson Principle. Remember your principle, explain your principle. And the Gibson Principle says the court will analyze the existence of agreement in terms of offer and acceptance unless there are exceptional circumstances. Full stop. House of Lords, Gibson, Manchester City Council. And then, of course, next sentence, just to tidy things up, in question 1 of your assignment, there are no exceptional circumstances in our question, full stop. And therefore, you have to look for an offer. Has it been communicated to the offeree? Look for acceptance. Has that been communicated to the offeror? Or has the offer been withdrawn before acceptance? So they're your principles, okay? And so don't forget to tell the examiner apart from the Gibson Principle, which gets you started. Obviously, you then have to define offer. You know what that is, don't you? And, of course, define acceptance. So look at the facts of the question. So you're now applying your definitions and principles to the facts of the question. Is there an offer? Okay, apply a definition, indication of a willingness to be bound on certain terms. Okay, and then, of course, has it been communicated? Acceptance, of course, final and unqualified assent to the terms of the offer. And then apply your acceptance principle, of course. Acceptance must be actually communicated to the offeror unless it's a unilateral contract. I don't think it's a unilateral contract in your assignment. Or the postal rule applies. And does it apply? Okay, and then you go on. Okay, and so you should have suitable subheadings in your answer. So I'll go ahead to this because the third bullet point says use subheadings where appropriate. Subheadings are good, and the best subheadings are usually issues, okay? So your subheadings should have a question mark. By the way, I'll go back again because I'll explain what that's all about. So everybody, this is why your... Oh, no sound. Okay, the sound is on. Yes, the sound should be okay. All right. Hello. Okay, thank you, Gwen. I'm glad you could hear him. All right. Yes, I mean, the sound is on. My microphone is unmuted and the volume sounds okay. All right, so so this is, I'm focusing on question 1 of the assignment, everybody. Now, it's up to you. You have to then come to some conclusion. You may well find one argument is stronger than the other. Don't panic if you can't come to a black and white conclusion on some of these issues. Why? Because you're not given sufficient information. And so sometimes it's difficult to say for sure whether there is a contract or not. Use your magic 2-letter word, if, okay? And if is a very important word when it comes to answering law questions, okay? So as I probably mentioned before, sometimes students say to me, Mr. Greener, thank you for that session on examination technique and particularly dealing with that particular question. But what was the answer to that question? I said, I don't know. So the students say, well, you can't be a very good teacher if you don't know the answer. I said, sorry, not enough information to come to a black and white conclusion. And remember, even in a case, a judge who has access to far more information than you get in an examination question and come to a, quote, wrong, unquote, decision. So it goes on appeal, okay? So don't worry if you can't come to a black and white conclusion sometimes. I mean, usually, quite often, though, the facts do point rather strongly to a particular conclusion, all right? So I just say to the students, well, have you identified the issues by using your definitions and principles? Yes, good. And did you apply that to the facts, arguing both sides? Yes, I did. Well, I say, well done. First class honours. Okay. So that's question 1, I think covers question 1 pretty well. Question 2 obviously deals with private nuisance. So obviously define private nuisance. And of course, the key issues with private nuisance are reasonable user. Okay, so you have to apply that to the fact. But probably the more important issue in question 2 of your assignment would be who can sue. That's the first issue. And of course, you know the answer to that, don't you? And so assuming that the person you're advising can sue because they have a legal interest in the property, then yes, then you go on to applying the definition. And of course, it's up to you to do, is it unreasonable interference with the use and enjoyment of the plaintiff's land? Well, remember that work we did on reasonable user. And of course, pay attention to what damage has been suffered by the plaintiff. Is it tangible? Is it actual property damage? Well, obviously that's unreasonable. St. Helens Smelting and Tipping, ACL and Bulmer. Or is it less tangible interference? In other words, you have to apply those factors, timing, duration, location, etc. Okay, good. So there you are. That's an examination technique with regard to the assignment. Question 1, all right, I've told you how to start that off. By the way, with regard to the assignment, hang on, got a question from Gwen. Sorry to interrupt, but is there somewhere we can see old completed past papers that we can use as how to answer? Yes, you are given revision handbooks, which I remember, and in those revision handbooks, there are past examination questions and there are model answers, and there are sort of guideline answers. I mean, there is no one perfect answer. That's another point to come up with. There is no such thing as a model answer. What it comes close, if you like, is answering the question that's on the screen. Have you identified the issues? And always good to put the key issues as a form of subheading. So I'll go on to that with the subheading here. Okay, practical tips for the exam. I'll go away, you. So as I mentioned, with regard to the assignment, highlight your sources of law. So, I mean, don't worry about the ones I've actually got on the screen. They're English cases. And also the legislation is English legislation, but of course, we are using Hong Kong legislation. So, but always highlight your sources of law. Why? Okay. Why should you highlight your sources of law? And by the way, when you are typing out your sources of law, the best way of highlighting is simply put it in bold print, as I've done on the screen. On the screen, I've also underlined it. That's unnecessary. Okay, simply putting the case law and legislation in bold print is sufficient highlighting. Okay, now why should you highlight your sources of law? Okay, well, for a practical reason. One is the person marking your paper, believe it or not, is a human person, and so it's always good to make sure that that human person doesn't miss the fact you've identified that leading case, you know, Gibson or legislation, misrep ordinance, whatever it is, okay? So that's a good practical reason for highlighting your sources of law. The other more noble reason for highlighting your sources of law is to give due respect to the source of law, okay? And usually when you are making any sort of assertion in an examination answer, you should be able to back it up with some form of authority, either a case or some legislation, okay? So if you're in an examination, by the way, where you obviously won't, not yet anyway, using a computer, then in an examination, always underline. This is why I've underlined what's on the screen here. Underline your cases or legislation, because that will highlight them as well. And by the way, if you do underline case law or legislation, do so with a straight line, not a squiggly line, which will only irritate the examiner. All right, that's very practical. Okay, so highlight your sources of law, your cases and legislation. If you're typing your answer, just simply put them in bold print. And if you just as an examination using pen and paper, underline your cases and your legislation. Okay, good. Third bullet point, use subheadings where appropriate. Subheadings are good, and remember the best subheadings are issues. What is an issue? You know, a question for the court to decide. So therefore, a lot of your subheadings should have question marks. Okay, now that's good, because if you put down your subheading, then you know what you are writing about. Good, and even better, the person marking your paper knows what you're writing about. Okay. Also, generally, keep your sentences short. I mentioned this when I talked about the assignment before, because the longer your sentence, the easier it is for you to get confused, and the harder it is for somebody to understand what you're writing about. So also keep your paragraphs pretty short. I haven't actually got that on the screen, but keep your paragraphs pretty short as well. I suppose it's covered in that third last bullet point. Cover 1 point per paragraph. And by the way, do have paragraphs. Sometimes I am marking papers which have no paragraphs at all. and I really throw my hands up in horror, go and have a cup of coffee, and then calm myself, and then try to mark it. I mean, structure is important in your answers. Obviously, what you actually write is more important, but how you present it, I think, is very important as well. So this is why I think you should have subheadings. Don't overdo the subheadings. I mean, stick to the main issues. By the way, with regard to subheadings for your assignment question 2, it's probably good to have a subheading, for example, where you are advising 3 people. So you could have, you know, I think the first one you're advising is called Ian. So you could have Ian versus whoever the defendant is. And then you could have another heading, Jack v. whoever the heading is, and then Leo. They could be 3 good subheadings as well. I mean, there's no hard and fast rule here with regard to what constitutes a suitable subheading. But subheadings are good, and use them where appropriate, because they help you focus on what you're writing, and they help the marker focus on what you have written. Okay. Now, also, I suggest that you single space your answers rather than double space your answers, but of course, no hard and fast rule here. The advantage of single spacing your answers is that your work becomes a bit more compact, and normally it's easier to focus on something which is in 1 page rather than over 2 pages. The compromise is to leave a small gap between your paragraphs. Okay. What you don't want to do is present work which is just a whole mass of words with no structure, no paragraphs. Okay. Also, finally, adhere strictly to time limits. Now, of course, in the assignment, there's no time limit except the general one. Make sure you hand in your assignment on time by the 23rd. Oh, it's exactly 1 month from today. So you got 1 month. That's tons of time. If I were you, do it earlier rather than later. Okay. So no excuse for being late in submitting your assignment. And in an examination question, of course, adhere strictly to time limits. Now, in the examination, your questions are divided into Part A and Part B. Part A is the short answer, 20-mark questions. And Part B is you do 1 out of 2 questions, each question carrying 40 marks. So I think you're actually told how much time you should spend on each question, but don't go over time. You earn far more marks in the first few minutes of your answer than you do in the last few minutes of your answer. Okay, so if you're out of time on a particular question, leave that question, get on to the next one. You may well find that once you've done the next question, there is time left for you to go back and finish the earlier one. Okay, but don't do what a lot of students do. It's clear from some answers that they've run out of time. Okay, because I almost finished half sentence. Okay, obviously write as neatly as you can in an examination, but I mean, don't write it out in rough and then go and write it in nice, neat writing. You haven't got time to write out your answers more than once. Okay. But you should plan your answer, and the best planning is to at least come up with the subheadings. That would be a good way of planning your answer. Okay. All right. So that's practical tips for the exam. All right. And remember, for the assignment, you will be typing it. So make sure you bold, just to remind you again, bold your cases, bold your legislation. Now, let's just think. In question 1 of the assignment, there is no legislation, so you don't need to bold any legislation, but there are certainly cases you will need to cite in question 1. And similarly with question 2, I don't think there's any legislation there. All right, okay. But in the examination, there will be legislation. So in the examination itself, be prepared to highlight the legislation. Some students just highlight the cases. All right. Good. Highlight legislation as well. Legislation is just as much a source of law as case law. Okay, good. So those points, everybody, there you are. And also don't repeat the question in the assignment. All right. I mean, if you want to have a copy of the question, keep it for yourself. But what you actually hand in to me to mark is just the answer to the assignment. Don't include question. Also, with regard to the assignment, the word limit is very generous, okay? So don't worry if you don't go anywhere near the word limit, because it is a maximum and a generous maximum at that, okay? Of course, don't go to the other extreme of keeping it, 100 words, you'll fail. 200 words, probably fail. 300. I'm not going to give a clear number. I mean, use your common sense with regard to how long your answer is, but don't panic if you don't come right up to the word limit, because it is a very generous maximum. Okay, good. So I think that's probably it for examination techniques. Now, if you've got any, so everybody just going back to examination technique, remember, we've already covered contract with regard to the must-know definitions. Don't forget your must-know principles, starting off with the Gibson Principle, then the acceptance principle, and then revocation of offer principle. Don't forget the part payment of a debt principle. Okay, folks and bear. Part payment of a debt is not good consideration for the whole debt, but remember there are those exceptions to folks and bear. Okay, and also don't forget the past consideration principle. Past consideration is not good consideration unless you can fit it into the facts of cases like Lampley and Braithwaite. Okay, sorry, I'll begin. Do you prefer to write the complete term like law? Oh, yeah. With regard to legislation, what you do in an examination is you write out the complete name of the ordinance first, abbreviate it, so with the law amendment and reform consolidation, or write it all out in full, and then abbreviate it to LARCO, and that's it. You can refer to the legislation as simply LARCO thereafter. And not only in that question, you can refer to it as LARCO in later questions if LARCO is relevant, okay? So whenever you mention any piece of legislation first, write it out in full, but then abbreviate it. So you can abbreviate the misrepresentation ordinance to MO. You can abbreviate the control of exemption clauses to CECO. And then you don't have to write it out at all in any part of the exam, including later questions, as long as you've abbreviated it, made it clear. Okay. Also, with regard to cases, do you need to remember both names? Well, yes, if you can, because it's a source of law. What happens if you can't remember both names? Well, one name will do. Okay. What happens if you can't remember any of the names? Well, that should not happen, because remember, with your must-know cases, remember them. But, if you have a brain fade during the exam and you can't remember the case name, you could put down in a decided case. Yes, but that should be very, very much a last resort. I have marked papers in which a student said in a decided case, and he didn't mention any case names at all. Okay, well, you may scrape through barely if you don't mention a case name, but you're doing yourself a grave disservice if you don't mention case names. Case names are very important. And remember, you give due respect to the source of law. And if you're going to give due respect to anybody, remember their name. Okay. All right. So that's with regard to cases. Do you need to remember the level of court? Well, if it is an important level, remember Gibson is a House of Lords decision. So obviously House of Lords is important there. So you should mention that. Because remember in Gibson, for example, the Court of Appeal came to an opposite conclusion. So if you've got a Court of Final Appeal decision, whether it be House of Lords or Court of Final Appeal in Hong Kong, yes, worthwhile mentioning that in your answer. So, for example, with regard to vicarious liability, remember the Ming An insurance case is a Court of Final Appeal decision. Okay, so worthwhile mentioning if it's a CFA decision. Do you need to remember the name of the judge who gave the leading judgment? Well, yes, if it's a very important case. For example, Lord Atkin in Donoghue and Stevens. but again, not absolutely necessary. You need to remember the year in which a case was decided. The answer, as far as I'm concerned, is no. Why not? Because while you should appreciate when a case is decided because of the surrounding circumstances, and obviously how old a case is significant, but in examination answers, as far as I'm concerned, you don't need to mention the year in which a case was decided. Why not? Because sometimes a case is decided, let's say in the year 2016, but it's not reported to 2020. So what year do you put in? The year in which the case was decided or the year in which it was reported? Okay. So, I mean, some lecturers differ on this, but as far as I'm concerned, you don't need to put in the year in which a case was decided, because it may well have been reported in a different year. Certainly you must remember case names. Certainly you must remember the level of court, particularly if it's a high level of court. Also remember some cases are not the highest level. Remember Williams and Roffey. Williams and Roffey is not a House of Lords decision. It's only Court of Appeal. So in that particular instance, the level of court is important, even though it's not the highest level of court. Okay, so that's with regard to cases. So everybody, I trust with regard to cases, you've drawn up your list of must-know cases for both contract law and tort law. Okay. Also, with regard to both contract law and tort law, you've got your list of must-know definitions. By the way, what are the must-know definitions in tort law? Remember, vicarious liability, must know. Remember, an employer is liable for damage caused by his employees acting in the course of employment. Okay. And also know those cases on vicarious liability. And also, obviously, the definition of negligence. Okay, it's where the elements of negligence, there must be a duty of care owed by the defendant to the plaintiff, and then breach causing damage which is not too remote. Okay. So always when you're dealing with a question on negligence, always write down the elements of negligence. Now, in your assignment, the tort that's involved is not negligence, it's private nuisance. Okay, but in the examination, you can bet your life that the relevant tort will be negligence, probably. So always when you're dealing with a question on negligence, write down all the elements of negligence first, and then it's up to you, everybody, if you're doing a negligence question, to identify which of those elements is at issue. And in traffic accidents, everybody, usually the main element which is an issue in traffic accident cases is whether there's breach of the duty of care. Obviously, you've got to mention, duty of care is owed by all drivers to all other road users, but you can simply cite Donoghue and Stevenson with regard to directly caused personal injury or property damage. Okay, duty of care could be an issue if the type of damage suffered by the plaintiff is either nervous shock or pure economic loss. Okay, and then the main element in issue in traffic accident cases will be whether there's breach. And don't forget Nettleship and Weston. Nettleship and Weston, everybody, must be on your list of must-know cases dealing with negligence. Because Nettleship and Weston says there's no varying standard of care for car drivers. There's only one fixed standard of care, and that's of a reasonably competent driver. Okay, so Nettleship and Weston, good case. We mentioned that before. Also, Nettleship and Weston, the defence of contributory negligence succeeded. Remember, 50% contributory negligence in Nettleship and Weston. Okay, good. So draw up your list of must-know definitions in tort law, vicarious liability and negligence, private nuisance also. Okay, public nuisance, you should have a workable definition of public nuisance. And then make sure for both contract law and tort law, your list of must-know cases and list of must-know principles. And remember, with regard to tort law, particularly negligence, the major function of tort law is compensation. Don't forget to work that in to any questions, certainly dealing with negligence. Okay, so that's with regard to your examination technique. So we are going to meet again in April for 2 revision classes. The first one will be on contract law. So I'll expect everybody to know all of those 6 must-know definitions perfectly, and also the principles involved. And we will be reviewing all the must-know areas of contract law when we deal with that revision class. And then also with regard to the second revision class, then we'll be covering the tort part of the course. Obviously negligence, private nuisance, and public nuisance. Okay, public nuisance, yes, is must know. You will not be asked a problem question on public nuisance as such, but there have been past examination questions asking you to compare and contrast private nuisance with public nuisance, which is what we talked about earlier tonight. Remember the 2 big differences between private nuisance and public nuisance? Well, obviously the definition of private nuisance helps. Remember, private nuisance is unreasonable interference with the use and enjoyment of the plaintiff's land. Key emphasis is on land, okay? So it's only a person who has a legal interest in land can sue in private nuisance. Not so in public nuisance. You don't need to have a legal interest in land to sue in public nuisance, okay? So that's one big difference between private nuisance and public nuisance. And the other big difference, of course, is, well, you know, my brain's going blank here. So who can sue? Well, we've covered that. The other big difference, of course, is that you can claim damages for personal injury in public nuisance, but you cannot claim damages for personal injury in private nuisance. So that's another big difference between private nuisance and public nuisance. And of course, these differences stem more or less from the description of both private nuisance, which the definition of private nuisance, and also the description, if you like, of public nuisance. Public nuisance is there to cover a much wider range of activities than private nuisance. Okay, so that's pretty well it for the night. Anybody got any questions? I'm here for a few more minutes, so if you want to ask me any questions in the chat box, feel free to drop me a line, and if not, then we shall call it quits for the night. I think we deserve a slightly early mark, don't you? We've worked so hard. Hang on. For negligence in Western, contribute negative 50%. Defendant had purchase insurance to cover the compensation, right? So plaintiff can further get 50%. No, well, hang on, that's a separate issue. When the defendant has got insurance, well, by the way, in these cases, it's quite often the insurance companies that take over. And of course, then if the defendant is found liable and they have to pay damages, then the insurance company will pay it. But of course, if there's contributory negligence of 50%, the level of damages is reduced. So the insurance company will be happy because they only have to pay 50% of the damages, not the full 100%. Although it is worthwhile mentioning, so Alice has got a good point in that insurance does play a big role in practice, okay? And by the way, every car driver in Hong Kong has to have this compulsory third-party insurance. So there, so quite often when there is a traffic accident, it's the insurance companies that get involved and take over the running of the case. All right, so contributory negligence, everybody, very important, probably the most important defense to negligence. And you know why, don't you? Because contributory negligence under Section 21 of LICO is only a partial defense, which means the plaintiff gets some damages, and you know the main function of tort law is compensation. Okay, all right. So contributory negligence, everybody. Oh, by the way, the other must-know pieces of legislation, apart from Section 21 of LICO in tort law, Don't forget section 62 of the Evidence Ordinance, which I've given you the PowerPoint on, not in your course manual. And I trust you all agree with me. It is very important because it says that in a civil action, any evidence of a relevant criminal conviction can be adduced as evidence in the civil action. Okay, so section 62 Evidence Ordinance, very important. And remember, section 62 of the Evidence Ordinance reverses the burden of proof and puts it on the defendant. So section 62 Evidence Ordinance, very, very good aid in proving breach of the duty of care. And so I would suggest section 62 Evidence Ordinance must know. Also, I would suggest section 12 of the Motor Vehicles Insurers Third-Party Risk Ordinance is must know as well when it comes to the defence of volenti. And of course, you know why, because it is a total defence volenti, but it will not apply if the incident involves a vehicle on the road. So I think you'll all agree with me, section 12 of the third-party Motor Vehicles Insurers Third-Party Risk Ordinance, yes, is very important. And I would classify it as must know as well. You can work that into an examination answer where volenti is relevant, then that certainly would earn you extra marks. Okay, so I would say section 62 Evidence Ordinance, section 12 of the MVI TPR Ordinance must know. But of course, section 21 of LACO, you must know. If you get any question in the exam on contributory negligence and you don't mention section 21 of LACO, then that's going to be very, very disappointing. Okay, also with regard to the contract part of the course, must know legislation, I would suggest section 7 of the Control of Exemption Clauses Ordinance, very important. Also, sections 2 and 3 of the CECO, quite important as well. Section 2 deals with definitions. Section 3 deals with the reasonableness test. Okay, so that's pretty well it, everybody. We do meet again in April for 2 revision sessions. What else have I got? Just see what I've also got here. I've got this bit. I mean, these, everybody, I don't think you need to worry about these. No, these are on essays, don't they? I don't know why it went that way. Okay. All right, practical. So the practical tips for the exams, they're the main ones here. And then there you are. All right, so now you know why I've been hammering you with definitions, must know definitions, with must know principles, because they will help you identify the issues, and that's what you need to do well in the examination, okay? And then apply to the facts, arguing both sides. Don't panic if you can't come to a black and white decision. Use your magic 2-letter word, if, okay? So if it's an offer, has it been communicated, etc. All right, if is a very useful word for lawyers, because remember, when it comes to an issue, there are arguments on both sides. And remember, it's going to be up to a judge in the case to decide which one of the arguments is the stronger one. Okay, so that's it for our course for the time being, everybody. You've got work to do on the assignment. You should be looking forward to doing the assignment now, because I've given you such deep hints that you should be looking forward to doing that now. And don't be late with the assignment. You've got plenty of time. You've got 1 month to do it. Okay, so that's pretty well it for me. Unless anybody's got any closing questions, then I will call it quits. So I'll leave the chat box open just for a minute or so, okay? But I think we've done pretty well on this course, everybody. Thank you very much for your attention in these online lessons, putting up with all the tech stress. Oh my goodness, Adobe Connect, there's always something going wrong with it. Anyway, but next time we meet in April, I presume it will be face-to-face. Oh, won't that be exciting? I look forward to seeing you all in person. I will look the same, probably. A few more grey hairs, maybe. Okay, so there you are. And I'm not sure where we're meeting, but I guess we'll be told where it is. Okay, thank you very much, everybody, and have a good rest of the evening. If you're having a shower, don't forget Capital, Prosperous and Sheen. Hong Kong people go to bed late, so having a shower 11 to midnight is reasonable, isn't it? Okay, so I think it's reasonable now to let you all go and do your revision, do your assignment, and I look forward to seeing you all again in April. So take care, keep the masks on, keep the hands clean, keep your social distancing. Let's hope the pandemic is much less severe than it has been. Okay, so that's it for me. Thank you very much, and I'll catch you all in April.